Good morning, everybody. We are graced with the presence of good Lawgic today, who also has a YouTube channel. So if you're not familiar with him, then you should go subscribe. You're also on Rumble.
Correct. Yes.
Okay.
Rumble,
So,
locals.
oh, right. Of course. Locals. Go to goodlogic.locals.com. Yes, we like to promote that over YouTube anyway. But if you are watching us on YouTube, we do think you're going to get most of it, but we may cut it at some point. Just forewarning that we're live on ROKFIN and Rumble, so you may have to go elsewhere to get the entire stream. We're not sure yet. We're gonna let the wind take us to where it goes. Okay, the first topic we're talking about today is judge orders discovery to proceed in social media collusion lawsuit against Biden administration. And after we talk about the generalities of that, I also want to discuss these emails that the AFL has released as part of its collusion lawsuit. How many collusion lawsuits are there right now? I don't know. But these are pretty interesting. They paint quite a picture of the CDC and its relationship with Twitter specifically, looking for disinformation, asking for help identifying misinformation, sending basically lists of this is what is real. These are the talking points that you all need to be aware of. Regular be on the lookout meetings where CDC would share what they categorize as misinformation. So I think that's all really interesting. But Joe, why don't we just go to the basics of this so if people aren't familiar with it, they understand what's going on here.
So essentially, the states of Missouri and Louisiana are charging that Biden is working, and various executive branches, executive agencies are working with big tech for the purposes of silencing smaller people. They're colluding with each other to take certain positions that seem rather un-American with their restraint on free speech, and this is, as you mentioned, this is far from the first case to bring this up. I mean, I can think of one. If you're familiar with Ron Coleman, I believe, and he works for the Dillon Law Group, and they have a case with Rogan and Hanley from DC Drano, which was basically alleging similar things. This is carries a little bit more gravitas in the sense that it's being filed by the actual states of Missouri and Louisiana, and accordingly, you expect that it's going to get, certainly at the outset, it's getting more respect from the court itself. Meaning the court is not blind to the distinction between a filing from an individual citizen, even if it's someone who was relatively famous, compared to a state filing an action saying that the actions that the president and his agencies are taking are unconstitutional. So what they're essentially alleging is that they've been colluding together, and what they bring up is that those of you who are familiar with it, you probably have heard about Section 230, and this is from the Communications Decency Act. Section 230,
which I never hear anyone talking about anymore. Hardly ever hear anyone bringing that up. Remember when it was like the biggest news talking point when Trump was president, and then it just died?
Right. Yeah, and what's interesting is it's kind of weird that when we used to hear, why do we hear about it? Because we used to see all these Senate committee hearings where they would haul in Mark Zuckerberg, they would haul in Jack Dorsey and start drilling them with questions in front of Senate, and that would be like a big TV news splash and nothing ever happened. And you would hear senators like Ted Cruz or Josh Hawley complaining that that big tech is censoring people too much, and then you get Senator Hirono saying that they're not censoring people enough and that they want them to do more, which you have to ask yourself, if you are Mark Zuckerberg or Jack Dorsey and you're sitting in that position, you're like, okay, what do we do with this? We have half of Congress yelling at us that we're not censoring enough, another half yelling at us that we're censoring too much, and perhaps we're actually seeing how they responded. They basically said, okay, they were hoping, it seemed as if there was a lot of information there, at least, that was promoting the, there was a lot of information that was, let's say, hostile to one side and favorable to another side that they seem to slant in favor of. And today, President Biden is our president, and the powers that are on display there, according to this lawsuit, are basically they're alleging that Section 230, which is a statute that provides great leverage to and protection, really is the word I was looking for. Great protection for big tech, insulating them from lawsuits, no matter how aggressive they are, or basically it's worded with language that is so open-ended that they can take steps with respect to controlling the flow of content without ever exposing themselves to the risk of being deemed in the eyes of the law as a publisher. And for those of you who are unclear, and just the overall parameters of Section 230 is for you to understand, you have to understand that the reason Section 230 came about, and the whole genesis which led to it, which came about in the mid to late 90s, was that we've all heard about the giant defamation cases and all these different defamation suits. So big tech was afraid that they were going to get hit with 1,000 lawsuits a day. And the reason that is that because the way defamation works is that if someone defames another person, and that defamation, the defamation is an untrue statement that's derogatory, made about a third party, and that causes them damages. Well, when someone defames a third party, anyone who is a link in the chain can be labeled a publisher. This doesn't really necessarily have to be a publisher like we have, the old school publishers of books, but anybody who helps transmit it can become a publisher. Anyone, in other words, if I write something, if you think about this, when any journalist writes something in a newspaper, so the journalist is the person publishing it, the newspaper is the one who's publishing it, they're both links in the chain. In theory, the local corner store, which is selling the newspaper, is helping distribute it also. They also could have been considered at one time publishers. But what the court did long before the 90s was they said, we're not going to hold the guy in the corner store liable. Let's say there's a lie in a newspaper. Even though he's helping distribute these lies that he's selling with the newspaper, we're not going to consider him to be a publisher of the statement that he could be sued for defamation. Because traditionally, anyone in the chain could be sued, and usually all of them would be in the chain. So if you're opening, if I have a chain, think about this: if you have a chain of big stores, big department stores, or big drugstores that are all selling newspapers, you could then sue, in theory, CVS for selling newspapers that are containing lies about you, and they would be in the chain. And the Supreme Court said, I think all the way back in the 50s, that we're going to distinguish between someone being called a publisher versus a distributor. A distributor cannot be sued, and a distributor is someone who has no control over that flow of information. They're really just a storehouse. They're literally what you would think, a distribution center. They're not really reading the papers. They're not helping author, or they have no control over the statements. And accordingly, since they're just distributing it, they will not be held liable. But anyone who has real oversight and control as to what goes into the writing that's defamatory could be held liable. So that would include both the author and his newspaper and his newspaper editor and the company itself, because they have real control. Section 230 was basically designed to protect big tech companies. It was specifically designed to encourage them that they should be allowed to exert control without being labeled a publisher and still being labeled a distributor. And the whole thought process was, okay, we know a telephone company, they're like a regular distributor. You couldn't sue Verizon if someone used Verizon to say something defamatory about you. So they said, well, what happens when it comes to big tech? They're not exactly like Verizon, because they can go in there. They can delete things. In fact, we want them to delete terribly bad things. We don't want pornographic material there. We don't want horrific violence being up there. And so they drafted Section 230 and said, look, even if big tech platforms at the time, it was really more Yahoo, and you didn't really have. I'm not even sure. Google, I think, was really in its infancy, or AOL. So they would have these different blog posts, and they would say, look, even though we want you to take down really horrific things and we'll allow you to do that, that might have otherwise put you into the category of being a publisher. But we're going to pass a law that says you are considered a distributor no matter what content you censor. And here we're coming to the heart of the matter, that big tech now has authority to censor without ever falling from being considered a distributor into a publisher. Because once they're a publisher, as soon as they become a publisher, then any yokel who lies about someone else and defames them, the person who gets defamed could sue, let's say, YouTube or Google or whomever is helping carry it. So that's what Section 230 stops the public from doing. And the problem with the language of Section 230 is really the key, because they gave different categories. They said you're allowed to censor anything that's pornographic or anything that's violent or harassment. And then they added in the fourth thing, just a few words, would say, or otherwise objectionable. If you're removing something for being otherwise objectionable, in that case, you still cannot be considered a publisher. You're still insulated from all these defamation lawsuits. So now what happens is they can censor whoever they want and just throw it under the rubric of being, this is objectionable, and accordingly we can basically take out one party's, anything positive about one party and say, I think that's hateful. I think that's something that people will be offended by. I think that's something that's triggering or whatever it is, and accordingly they'll end up they could really help one party and harm another party without ever being considered to be a publisher. Traditionally, that sort of activity would make someone a publisher. It would say, hey, you're really just a journalist yourself. You're allowing some things in, keeping other stuff out. You now become a journalist. Well, what this lawsuit now is essentially claiming is it's not that what the Senate and the president have done is they've taken the reins of these big companies like Google and like Twitter, and they say, we want you to censor things that we think are objectionable. So now you arguably have one party saying, we're going to basically create a hotline, which is what the Rogan and Hanley lawsuit is alleging. And if someone's putting out information we don't like with respect to a disease or with respect to various news stories that come out, we want you to censor them. And they're creating like this disinformation group, and that they're basically wielding their authority. And what's argued in this complaint is that they've been holding as the sword of Damocles over big tech, saying, look, if you're not going to do things, if you're not going to play ball with us, we can always rip up Section 230. So what the left is argued in this complaint is saying is that Biden and these various executive agencies are working together with big tech, and that big tech is either a willing partner or an unwilling partner, because they're afraid that if they don't do whatever the government wants them to do, that they're going to lose this protection. And if they lose that protection, that they feel that they would be very exposed to tremendous legal liability. That was a very lengthy explanation to a really simple question, but I hope it.
Well, it's good. I think it's good you went through the history of some of that, because, yeah, I mean, it wasn't even on my radar a couple years ago. I wouldn't have known what Section 230 was. So, no, I appreciate it. One thing that seems to be unique, and maybe I'm wrong about this, but they're saying, and of course, I'm curious, Eric Schmidt, of course, just won the GOP primary in Missouri. So he's running for Senate, I believe, there. And, I kind of wonder, like, did this pair with his knowledge that he was going to be running for another office, and wanted some good publicity? I mean, not that, hey, if it works to open up speech online, I mean, I'm all for it. But I always wonder about that, because, like, our attorney general in Washington, I mean, I actually had one of his former staffers on talking about how he runs it as his personal law office. And I remember he used to jump on like everything Trump. He would sue Trump over everything. So, because that was going to help him with his base. So I always wonder about these AGs, but whatever.
That's a really insightful question, because and it really can be both, can it? If you think about it, it's that hey, look, I'm running for office. This is going to get my name out there in front of the public and let my constituents know that I'm the MAGA guy you want, and this is the steps that I'm taking, and that it could be something that's very beneficial to him on a personal level, and at the same time his claims could be true. The reason I'm suspicious, like you're saying, is because I look at the relief and I say, okay, what are you going to get at the end of the day if you win? What are we really getting? And, because the complaint, whenever anyone files any complaint, you always have to demand from the court or respectfully request of the court that they let you know, that they tell you, okay, here are all the issues I have. This is what I'm hoping at the end of the day the court is going to do for me. And if you look at the relief, it's okay. It's basically declare this to be unconstitutional, impermissible activity. So what do you want? Do you want the court to basically say you're bad guys? You don't do this anymore. There's no other. What do you want the court to do? Like what? It's not like they're looking to have to get money out of it. You're just what relief are you looking for? That the court's going to say, okay, we're declaring now that you shouldn't do this anymore, which is really what they're saying. They're asking for that this is unconstitutional. You shouldn't do this. So does that mean it's not going to happen behind closed doors 10 minutes after a judgment is issued? I mean, I guess in theory, if we trust that the government is going to be following a court order, okay. I mean, if you think that Biden and Harris, and Pelosi, and this whole group, and I'm not saying that because they're Democrats. I'm saying if they're Republicans also, whoever it is, they're going to say, oh, okay, well, I guess, Judge Johnson, I never heard of 20 minutes ago, issued a ruling. So now we're never going to do this again, because that's what Judge Eric Johnson said down in Louisiana. Like, I guess the whole party is over now. I'm sure they would take some steps publicly, but for me to believe that nothing would ever happen, that they're really going to change their activity, that all of a sudden they're going to stop talking, that we're not going to have Fauci communicating with Twitter anymore. You're not going to have these different agencies talking behind the scenes with Google or Facebook. Please, come on. It just means you got to cover it up now in the public, instead of Psaki saying, yeah, we're talking to Facebook. We're telling them what to do.
So since you brought that up, I went to some of the emails that the AFL got for their lawsuit. These I think are almost all between Twitter and the CDC. And so it's like, Hi, Carol. I'm looking forward to setting up regular chats. This is from Todd at Twitter. I'm looking forward to setting up regular chats. My team has asked for examples of problematic content so we can examine trends. All examples of misinformation are helpful, but in particular, if you have any examples of fraud, such as fraudulent cures, vaccine cards, that would be very helpful. Thanks in advance. And they're like, okay, we'll get that to you early next week. Thanks for checking in. So you're saying maybe they'll just go to phone calls or something? I mean, I wouldn't be surprised.
I'm just saying, like, this was like an official policy. So I guess if they wouldn't be allowed to have an official policy. Look, I guess that's a potential benefit. The other potential benefit, I guess, is that the more we see about this intermingling of big tech and government, the expectation is that if they're viewed as being an arm of the government, that really changes their abilities to do what they're doing without having this exposure. So there's really, as far as what the long-term benefits are, if we think about this, assuming that the plaintiffs are successful, which we don't know if they will be, but assuming that they are successful. So first of all, this discovery process, which is happening here, is really shedding light about the extent of intermingling between Congress or various executive branches and their minions with big tech, where it's practically like, they can get on the phone, and it seems to only be like people from the Democratic Party, that they have like a hotline practically, to Mark Zuckerberg, and saying, hey, you need to ban this account. Or Jack Dorsey, which I guess not Jack Dorsey anymore. He was replaced he was in power at I think the time this thing went underway, but he stepped down. I forget the name of his replacement, but and basically go to Susan Wojcicki and say, hey, you should shut down this account in theory. And the level of influence that is terrifying. I mean, that's a really terrifying thing. And Jem Psaki, when she pretty much came out and said, yeah, well, we're in contact with Facebook. And it's like, really? Like, you guys are talking on Facebook, and they're not considered an arm of the government, and they're like, well, and then on the one, this is a frustrating thing, because on the one hand, it's like we keep hearing, oh, well, these are private companies. Private companies can restrict whatever they want. They can do whatever they want. They can restrict what they want. Yeah, okay, but these private companies have been built up by Section 230. They're insulated from it. That now they become powerhouses by an act of Congress, which was a poorly drafted thing to start with, and has become tremendously outdated compared to today's current technology. I mean, part of the reason that they got this protection is because the government wanted to get the internet off the ground. In the late 90s, no one was using social media the way they are now, and social media, big tech didn't have the capacity to monitor information. They really were much more like a distribution center. It's like if there was terribly graphic things that were being shared, it would have to be called to their attention, and probably by a bunch of people before they wake up and they're like, oh my God, there's straight out, terribly evil types of pornography. We should take that down. And it would take, there'd be like a lengthy process to get it undone, as opposed to now, before the guy finishes uploading something, big tech knows about it and can like zap it out right away. So it's like, it's not like it's the amount of oversight that big tech has because of advancements in technology almost makes you question, what it makes you question whether the wording of everything here should be somewhat changed anyway. So yeah, I think Section 230.
Can I ask you a quick question, Joe?
Yeah.
Okay, because somebody in the locals chat that I have going on my locals page right now was asking about, would this exchange be appropriate between a media organization? Let's not talk illegal or legal, but let's talk about appropriate ethical behavior. And then I have a question about legality. So all the time, the government is sending press releases, whatever it is, a local health authority, as they say, LHA. Right. That's like the new term, or the federal government or the state government. I mean, they send press releases constantly to newsrooms to talk about whatever it is that they want the press to just regurgitate for them. And so would it be normal for you to see like, oh, hey, could you send us your list of misinformation? And I mean, if a journalist, I would say, if a journalist wants to compare, let's see what the government calls misinformation versus what we've fact checked to find out maybe that's just a government propaganda talking point. I think that's a fair story. If you're just writing the news organization and saying, hey, can you give us your misinformation so that we can like go after people and blot them out and you just take the government's word as gospel, then that's not journalism, right? That's just being a government mouthpiece. But I'm curious from like the legal standpoint, I guess it's an interesting question. So why would it be, is it just Section 230 that makes this a legal case between the tech companies and the government? What happens if the government pressures the media organization like NBC? Is that illegal? Or is that just, is that allowed because these organizations don't have the same kind of protection clause? I mean, I guess I'm confused. It's kind of an interesting point. Like why can the government pressure media organizations, if they do, to run certain stories or to have influence with them? Because like in this case, they're saying what the government has done is suppress other voices. That's really at the heart of it. It's like not necessarily that you have your ideas about what you think is right or wrong, but that you are actively inflating the influence of some and suppressing the influence of others, and you're flat out wiping and silencing certain voices. But let's think about it. Like, I know I'm not posting to NBC for their story, But they do that, like, you know, regularly. If you say, okay, I'm going to go with the government narrative, so I'm not going to interview that doctor. That's, I guess, a silencing of a voice per se. So how come the government can influence these corporate media companies and there's, you know, nobody files suit, but there's some kind of legal loophole to do that with the tech companies? I guess I'm just a little confused. Does that question make sense?
Yeah, it does. So Nancy Pelosi almost like said the quiet part out loud when she, and I'm sure she regrets it because it's been thrown in the left's face a lot. Even though I'm sure the right does at times also. To be fair, I don't think we're dealing with saints on either side of the aisle. No one should mistake that. But you know, the left is the one in power now, so they're the ones who the focus on certainly more. The she described the wrap-up smear, which is a term I'm sure you have you heard this term, the wrap-up smear?
Mm-mm.
You should pull this up. It's a 30-second clip. Just Google right now, pull up wrap-up smear Nancy Pelosi, and there's like a 30-second clip where she describes exactly what you're talking about. Where it's not just that they're feeding the story. They'll make completely empty stories true or seem true in the eyes of the public because it'll be reported. They'll say something to someone and then it gets reported. And then once it's reported, it becomes validated. And then the person who said it initially and made it up is like, well, that's what newspapers are saying. And now it's become something that becomes essentially fact. And she said it's got a name, and it's called the wrap-up smear. And it was like, wow. So as far as politicians using the media to get messaging out that can completely to get, so I don't know if you have the actual clip there. You have the clip there?
Do you want me to play it?
I think you can. There's nothing wrong with it. It's like a 30-second clip.
All right. It's not going to get us booted off YouTube or...
I don't think so. No.
This comes from a news organization, so I haven't watched it yet. They may be fact checking this as false. So I have no idea. Let's see what they say. Okay, here we go. Let me know if you can't hear it.
To know if a video of Nancy Pelosi discussing a tactic called wrap-up smear is real. Here's the clip.
You smear somebody with falsehoods and all the rest, and then you merchandise it. And then you write it, and they'll say, see, it's reported in the press that this, and this. So they have that validation that the press reported.
Some websites are sending around this video as proof the Democrats made up the assault allegations against Brett Kavanaugh. That is fiction. The video, while real, actually shows Pelosi last year accusing Republicans of using wrap-up smears. She was not saying that it's
all right. So I think that's covering
Democrats.
it.
Okay,
but
there you go.
You heard what Nancy was saying. That you understand what she was saying. That basically,
yeah. Well, she knows more about, I guess, the propaganda than I do. So that's interesting, even on its own.
And she's explaining how they play ping pong with each other, where you basically smear something, it gets reported in a newspaper, and then you can say, well, newspaper reporters are saying this about that guy, and it becomes this circle jerk, essentially, where as soon as one person says it, it's said by one member of Congress, sometimes it can be even anonymously. Right? And someone come up and say, I'm giving an anonymous tip to the newspaper, or the newspaper reports it, or it doesn't, I don't know if they're even called newspapers anymore. The news outlet reports it. And then Congress starts talking about, well, this is what the newspapers are saying. So we have to, and then it becomes, well, now we have these people on record who are saying it. And it becomes like that's what I meant by circle jerk. It's just like, there's no one behind anything. It just becomes let's create a story and give it legs. So that does happen. The difference is this, though, and obviously it's disgusting, and it makes you question. It makes you understand why no one trusts anything that comes from Washington, and a few people. Fortunately, a lot of the country is waking up as to how ridiculously corrupt our media is. But there's a difference between that, what's happening with big tech, and why this lawsuit is commenced, is because if a private agency wants to lie and help a party, whether you think it's CNN or MSNBC helping the left, or whether you think it's Fox News helping the right, at the end of the day, they're private agencies. They can express whatever private opinions they want. The difference in this lawsuit and what makes this so consequential is because if these allegations are true, now the government is influencing free speech, which is an obvious violation of the First Amendment. If the government is going out and closing off people from being able to have access to the public, now if you have these big tech companies doing the bidding, it's not simply that they're news agency, but they're news agencies which are lying for Congress or helping Congress, and private agencies could do that. Now people, the third parties who are being targeted, are losing their ability to have freedom of speech because they're basically being muzzled from the public. So that, and at the behest of members of the government, and that seems clearly, to one would think, to be a violation of free speech.
So do you think that any of these lawsuits, because you were bringing up how you're not quite sure what the end game is in the Eric Schmidt lawsuit, but do you think any of them are going to serve a purpose at all?
Yeah, I do think that the hope is this. There was a dissent that was issued by Clarence Thomas roughly, I want to say about 2 years ago or so, where he was talking about Section 230, and he was talking about the issues that he has with it. And it was almost as if he was sending a message to the public that he's looking for the right lawsuit to declare this to basically be an invalid. That might be, that's not it if it's from April 2021, but he has hinted repeatedly that he's looking for the right case to basically, I don't know if he would say that it's, I don't know if he would invalidate Section 230, but to say that certainly if not invalidate it, to basically say Section 230 doesn't have quite the implications that everyone thinks that it does. There are different bases, and what he's basically saying is, if in fact, we look at these, as far as how do we view these big tech compared to how we looked at things historically. For example, you talk about common carriers, right? And whether something is considered a common carrier. Well, if something's considered a common carrier, there are certain rules and regulations that apply to it. For example, Verizon can't say, even though they're a private company, since they're a common carrier, they can't say, well, you're Jewish, so we don't want to let you use our service. You're Black, we don't want to let you use our service. There's certain things that are, and there's certain guidelines with respect to how they have to act. And basically what he was talking about is that he was looking at the possibility of having big tech qualified potentially as utilities, where it's like, look, the utilities are something that's a necessary thing for all people, which might not insulate you that you have the right to just silence people and get rid of them. But I think a lot of people who are hoping, especially on the right, who are hoping for help from Clarence Thomas to influence the rest of the bench, especially now that it's deemed to be an ultra-conservative 6-3, which is definitely not ultra-conservative. It might be conservative leaning mildly, but even though you have six members of the Supreme Court who were brought in by Republican candidates, I don't know if anyone will qualify. I don't think any conservative considers Comey or Roberts, certainly, or Kavanaugh to have very much in the way of conservative leanings, despite a series of decisions in June, which certainly the right was applauding. So,
okay, I don't know if this is it. I just found this one. This was another.
It was like, this is it. Oh wait, is this it?
This is interesting. Okay, so
Christina, that was it. You found it.
Christina writes under the name Radix Verum on Substack and does a lot of national security reporting. So you guys should go check her out. She's been on a bunch. She's a wealth of information on this stuff. And she's saying Google has its foundation in a joint CIA NSA research grant. What I've never understood about, because I do believe that they're collecting all this data on us. And that's why I always think like the VAERS reporting system for vaccine adverse events is so interesting, because they're
that's where you don't want to go.
Yeah, no, I'm not going into the specifics.
That's where you don't want to go.
I'm not going into the specifics. But I think that system is interesting, the way it's discussed by the government, because they always say, well, you can't trust it because anyone can say anything, and, it's not vetted and whatever. Like, okay, so you haven't figured out a way to make a reliable system there, and yet you're tracking all these other things. You figure out how to track all these things, except this
Yeah.
one thing. It's like, we just don't know it. We don't know how to track it. We're just lost. We just can't figure it out. It's like, nah, they figure out how to track you where they want to track you. But my question about all this is, why? Okay, on one hand, I kind of wonder if it's like you really ever go away on the internet, because if in fact the internet, let's just go down that rabbit hole, is a place that you're basically data mined for surveillance purposes by security agencies, then why would they want to get rid of people's voices? Because you would think they would want lots of stuff out there so they could keep tabs on people. Then my next question is, then when they delete a voice, do they just not really ever go away? I mean, are they still tracking you? They're just taking away your influence on other people.
Yeah, that's what I think. I think that's the last thing. They don't want anyone to be able. They want to know where you are. They just don't want anyone to be able to listen to you. So, I mean, it's the ultimate. That's the way it works. That's the way it works in any sort of authoritocracy, where it's like, yeah, of course we need to know where you are, but we don't want you to be able to convince minds to do anything that we deem to be adverse. So yeah, that's what autocracy is.
So then ultimately, where do you see this ending? Because I guess the big question is, does the internet ever go back to what it was 20 years ago, or does it just become legacy media?
Does the internet become legacy media?
Yeah, just like, or government, an arm of the government. Does it just, because like they're already promoting CNN and Fox News, and over the smaller subscriber, it's very difficult to be a content creator who does news content at this point, that doesn't have a big media backing of some kind of mainline legacy corporate press organization behind you. So do they just keep going in that direction and then just become more obvious about it, I guess, and just become a filter, like a digital arm of these TV or newspaper organizations, just a way for them to get their audiences grown, and then their filters for the government? Because because a lot of people think that eventually there will be a lawsuit that will break, or there will be some kind of Supreme Court ruling, and maybe the internet goes back to where it was. But I don't know how this goes.
When you say goes back to what it was, you mean what, as far as actually being free speech versus something that's censored?
Yeah, and like maybe it wasn't ever really free speech, but just
relatively free.
Yeah, it was yeah, like you could they weren't like the community. I don't remember even any community guidelines on medical stuff until COVID. Maybe I just missed that, but I don't remember. It just seems like there's more and more community guidelines. So eventually going back to a place where you could talk about stuff where without like 600 pages of community guidelines that you could get struck for.
Right. In other words, when it comes to someone having a clogged ear, you could talk about homeopathic remedies and no one would say you're banned from the internet, as opposed to new diseases now, where it's like, no, unless you go along with what the government is telling everyone to do, you're exposing yourself potentially.
Yeah.
So can we go back to that? Yes. Do I think it's going to be something that'll happen very soon? No. You're seriously, you talk about the small creator. We are living in the age of the small creator right now. And big tech, which is part of which has become part of legacy media, and legacy media have a very healthy marriage with each other to promote each other, if not engage in becoming legacy media themselves. But they have a healthy marriage, and I do think that the rise of the small creator should really be your viewer's best hope. Don't look to the government to fix this. That you should have very little hope for. I don't think you should have very much more hope in the court having the ability to fix the current climate. What ends up fixing the current climate, if anything, is the bottom line, meaning the dollar. Right? When you talk about what the dollar is, if they see that places like Rumble or whatever, which have real open markets, and small creators have ability to flourish without being squashed for expressing opinions that a multi-billionaire dislikes, Well, in that case, I think that we'll see a corrosion of that power. Yes, of course, on one side of the aisle, you can see. I can foresee certainly a further widening of divides where it's like, okay, we'll know exactly, tell you exactly who you voted for in the last 3 elections based on which platform you're on. I mean, I wouldn't be surprised to see things continue to devolve along those lines. But at a certain point, I think these corporations are about money. So, if you don't have to chew up, you don't have to chew up you don't have to chew up your own hand, which is feeding you. You have 2 hands feeding you. You don't have to chew off one of them just to make the other one stronger, and then watch that other one, send all that food somewhere else. So, and that's why I would think at a certain point, I don't understand how. I can come up with theories. I can come up all day with theories as to why it is that various big tech overlords would be favoring their own power by basically silencing one side and leading in certain directions that a lot of people would label conspiracy theory. But as far as if someone looks at traditional capitalist markets, you would not think that this would be favorable to big tech to actually chase off half of the country to other platforms.
Mm-hmm.
Now, if there's a different agenda behind it, which a lot of people would speculate there are, I can come up with a lot of interesting ideas as to why that would be. I can speculate with you on that, but as far as what their ultimate motivations are. So, but here, that's why I'm constantly pushing people to places like Locals, to places like Rumble, because it's ridiculous that we can't have this conversation. Think about how stupid this is. Like I have to sit here worrying you. Hey, it's theirs. Be careful what you say now. Well, why? Why the hell would that be? And,
I know
we shouldn't be living.
It's a government website. It's a government-run website.
And that's what this lawsuit is about. It's like, this is a government-run website. Why the hell can people not talk about theirs? Why? Why the hell can that not be? And that's why they want to talk to Fauci. And that's part of the interesting thing is they're sending interrogatories, which are a discovery vehicle, saying, hey, we want to see your emails. We want to see your exchange of information here and the directions that were happening between Fauci and various big tech companies. And I think that some of these conversations can provide some really interesting, revealing fodder. So we start getting a better flavor as to exactly how much control has been either forced upon big tech or gifted by big tech to Congress, and for the purpose of gaining influence with Congress. Like, yeah, we'll give you a hotline. We'll give you a hotline that you can just call up Mark Zuckerberg, Fauci, and or Mark Zuckerberg's, chief of operations, who can crush anyone from Facebook with a snap of his fingers, and they're literally gone in 2 seconds, and no explanations are needed or ever given, or do it on YouTube or Google or Twitter or any of the Apple, and how much, and if they really are exerting that type of control, in that case, it seems as if that then the court can intervene and say, like, look, this is a violation of free speech, and the government can't do that, and accordingly, this activity has to be reinstated or whatever, or start perhaps when there is a little bit more balance of power in Congress, that could lead to changes as far that could positively influence big tech and how they act.
It may have a ripple effect socially, culturally, like at the very least, that it at least gives us a better cultural and social understanding of how we're being manipulated. And maybe at the very least, that means grandma gets to come back over for dinner for Thanksgiving because she voted differently than you or something.
And she's still out there on the West Coast by you. She still can't come by you. Is it still that bad?
But I grandma eats too much of my leftovers, so I don't let her, I can't.
You let her come around?
Okay. Yeah, we can't afford to have her over. Okay, I want to move over to Alex Jones in a second, but before we leave that conversation, there was one question on Locals, and since you were pitching Locals, everybody go to our Locals pages. I'm at AllisonMorrow.locals.com. Joe's at Good Lawgic. And not LOGIC, LAWGIC. Good Lawgic. .locals.com. in the big tech collusion lawsuit, are they suing for a particular amount, or is the lawsuit being brought forward to push discovery? What kind of punishment would the Biden administration face, if any, if found guilty? We talked about a lot of this. Was there anything else that you wanted to point out?
No, it's really just a declaratory statement that the actions are illegal and violative. If you go to the wherefore clause, it's not very lengthy. In fact, I'll actually read it off to your audience so that they don't have to bother digging up this article. So what the relief they ask for is declare defendant's conduct violates the First Amendment, declare defendant's conduct is ultra-virus and exceeds the statutory authority, which basically means that they never had the right to enact these statutes, or these if not statutes, these executive policies. Declare the defendant's conduct violates the Administrative Procedure Act. It's basically a declaration that their activities are wrongful. So that's why I asked the question. I speculate whether really it's Eric Schmidt looking to help raise his political proffers more than actually benefit.
I see.
But because so now it's all declared. And the other thing is preliminarily and permanently enjoin defendants and officers, agents, servants, etc., and all persons from acting together in participation with each other. Like that's, so there'll be a statement from the court saying, "Hey, Fauci, you can't act with Susan Wojcicki." Okay, all right. So does that mean you're not going to have someone from Fauci's office talk to like,
right?
Just because this judge, some small judge says it. It's not like the Supreme Court. I mean, it's not even like Justice Thomas that they have to be answering to, or Justice Roberts.
Well, there's a will, there's a way, and I still feel like that, no matter the technology, the government is always going to figure out a way to try to manipulate the public. I mean, even if you get some positive ruling in these cases, there'll be a new way. After I left TV news, a lot of people know I shot wildfire videos for the State Department of Natural Resources. And, I did a very mundane job. I just went out and talked to firefighters and stuff about what it was like being on the front lines of wildfires. But I was privy to conversations about how things worked. And, there was a lot of phone calls and like deleted emails and stuff like that. They know how to work it. I mean, the government knows how to get around if they want to. In this case, it may just be laziness or self-righteousness, hubris, who knows, that left this trail. But okay, so their lawsuit is in the favor of free speech against the government, so they'll just be more careful about what they put in writing and
admitting it. You won't have Jem Psaki telling the press, we're in contact with Facebook.
Right. So, exactly. Yeah. They'll just be more secretive about it. So and then I don't even know, maybe that's worse because then people walk around with this false sense of freedom. Okay. So you think that we don't need to cut the stream on YouTube?
If you're worried about it, we can cut it. I don't care. It's up to you. I don't think we need to worry about it.
Okay, how about we do this? We're going to talk about Alex Jones and Steve Bannon. Let's do a brief YouTube version.
A brief YouTube version?
And then we can go into depth on the other platforms. Let's just do that.
Okay.
Well, the question on my locals page about Alex Jones was, what did he violate that warranted a $4 million payout to the Sandy Hook parent? What law did he break?
So there's
are they alleging?
So they were found. He was found guilty of.
Mm-hmm.
So this is an interesting and a little bit confusing for the public at large distinction between defamation and intentional infliction of emotional distress. So defamation. Most of you who follow the Johnny Depp trial, you understand that's someone makes a statement, publishes a statement that is untrue and derogatory and causes someone else damages. IIED, which is intentional infliction of emotional distress, can seem similar. And in this case, it does seem as if there's overlap, and that was one of the emotions that was brought by the defense, saying that you can't have the same action be two different causes of action. There has to be different elements in there. And the court ended up parsing out different actions to find in favor of the plaintiffs and let the causes of action both continue. But IIED is basically someone who is essentially trying to harm someone else, trolling essentially, and causing that person you have to have a manifestation of genuine, you have to have mental pain that manifests in ways that we will see it. In theory, for example, someone who literally is like trolling someone, trying to harm them in old pranks, and let's say they actually talked about a case, one of the landmark cases there that was brought down in Texas, was I think it was called Boyle v. Kelly. I was looking at this like a week or two ago, which was a case where a bunch of frat boys basically lured one that was popular, lured a girl into his dorm and engaged with her in a private in private ways, while his friends were filming it from the closet for the purposes of of harassing her. And that actually ended up becoming one of the more landmark decisions as to whether or not that case could proceed under a different theory of negligent infliction of emotional distress, not intentional infliction. But I don't want to sidetrack with that, because there's negligent infliction of emotional distress is not really relevant in this case. This was about intentional infliction. But essentially, that's what IIED is. Now, if someone makes a defamatory statement that can be deemed as sort of like intentionally trying to harm someone else, and that person suffers for it, so it seems as if you did both defamation and IIED. There seems to be a significant overlap there, but you could basically parse out that this IIED, there has to be, you don't need to have a statement at all. There could be no statements at all, and there could be IIED. And also what you have here is you need to have a showing of real pain, like literally pain in your mind that manifests in an inability to sleep, inability to work or eat, or depression, things of that nature, rather than someone saying like, well, he intentionally caused me emotional distress, and as a result of that, I feel terrible, but I haven't gone to a doctor or whatever. You know what I'm saying? No one ever sees me crying, but I was just really embarrassed by it. There needs to be like manifestations that the court has said in Texas, and I think this is similar in most states, that you have to actually have a manifestation of the pain that you're feeling in your mind. So what happened here was, Alex basically made statements that were to the effect that after he made statements and I believe after an interview with Megyn Kelly in 2017, where he was questioning the stories of these parents, Mr. Heslin, and I think and his and the mother of I think his name was Jesse Stewart, who was the child who was killed in Sandy Hook. And he was questioning whether or not their grief was sincere, whether or not he was telling whether or not he actually held his dead son in his arms as he had told the media, and he was questioning it, and basically that was considered to be an intentional infliction of emotional distress. Now this case became very peculiar, like really like a lot of crazy different things happening. The first and foremost was that the defense was stripped of their ability to defend for liability. So anytime there's a civil action, you have to find the person liable, and then you need to assess how much of the damage is. Liability is, you have every cause of action is going to have a series of elements, that's or ingredients in your cake in order for there to actually be liability. And once we put all that together, then we say, okay, how much were the damages? So in fact, many cases are even bifurcated into two different trials in theory. When someone fails to follow court orders, which Alex Jones was found to fail to follow them on multiple occasions, I think like 6 or 7 times, the court has the ability to say, well, we're essentially striking your pleadings. We're looking as if you didn't answer at all. And now we're going to assume that you're guilty and all the liability element is gone. And we're going to assume that you're guilty of everything that the plaintiff is claiming. And all that we have left now is how much were the damages. The whole liability section goes away, and we assume guilt on behalf of the defendant, and then we figure out what damages are. So now that's what this trial was about what the damages were, because there was default judgment entered based on his failure to respond to discovery demands.
So that was the part I remember being the contentious, debated part when you watch Viva and Barnes. Like when you listen to Robert Barnes talk about it, he says, and granted, I mean, Robert's obviously like hosting the show for Alex, so there's a connection there. Right. But he says that Alex didn't not turn over. What's the right way to say that? That what like I remember listening to him saying, what was it that he didn't turn over, and that's a debated piece of fact, I guess. I think not true in his opinion.
Right, I understand that. And Robert makes. I have all the respect in the world for Robert. He's a brilliant attorney, and he makes fair points that the amount of discovery that Alex Jones engaged in would make you question and say, well, why is the court being so punitive and so harsh on him that they're gonna enter judgment against him and make it and turn this into a damages case. It's unusual normally for a judge to take that route when someone seems to be acting in good faith and turning over and appearing for depositions, which he did. He appeared for depositions. He took all these steps in discovery, and still the court said, you didn't do enough, and accordingly we're entering judgment against you. Well, that's true. It's a very weird thing. And I'm sure Robert who has a great deal of experience, is spot on that few people have ever seen cases ever in history where someone has taken such long strides towards engaging in discovery and still have default judgment entered against them based on the judge's finding that they didn't engage in discovery sufficiently. At the same time, when there are repeated statements that various text messages have to be exchanged, and you flout the authority of the courts, and it goes and you appeal it, and you keep appealing, and you keep losing with the court saying, no, you have to turn this stuff over, and you still don't. So then you're sort of almost putting the court in a position where, like, okay, what are they supposed to do? They can't have someone flouting their authority and say, well, even though the court's telling me to do it, I'm not going to do it. And the judge did give them multiple opportunities to rectify. And I think that Alex Jones probably felt that some of this stuff, he probably felt it would be better to have a judgment entered against him than to disclose some of the stuff that he was being asked to disclose from a financial perspective. I know it sounds crazy, but it actually has come out because of disclosures that were actually accidentally made. When you talk about the amount of money that InfoWars makes on a daily basis, I don't know if you heard this, but supposedly they make on some days $800,000, and on other days like $100,000. It's like that. I mean, that's what they're bringing in daily. You can understand why they don't want the public at large to know that number. They don't want the public at large to understand the type of information that the type of money that they seem to be making, because that really paints them as like someone who, and I can't believe it's $800,000 a day. I mean, that would be ridiculous.
That would be like what you're bringing in on YouTube.
Right. Clearly. Yeah, exactly.
Hey,
you're one to talk. You're one to talk.
I can see excuse me, I can see your point on someone, I don't know in this case specifically, but on someone choosing which poison pill they would prefer, like you said, disclosure versus, taking some punishment for something else. Right. I think for me, as somebody who has a very superficial understanding of this case, and just like I said, has listened to Robert describe it as a show trial, and then has heard other people say, when you read the corporate press, especially, that this is due justice, it's happened, and like, where's who's telling the truth about it all? I mean, it's like one of those things. It feels like you had to really be paying attention to it every day and watching it and really consuming it in real time, like actually watching the proceedings and reading the documents yourself. And so just like saying, I have a very superficial understanding of it. Mm-hmm. However, the flag I always have with Alex is when a couple of years ago, he was banned from these social media platforms. You know, a lot of people just didn't pay much attention to it. And then it did start to creep in closer to everybody else. And I
Canary.
think
He's
the
the canary in the coal
question
mine.
that I've heard posed, which I think is a fair one, is, are we watching a new precedent set with Alex Jones? In other words, you know, yeah, you have this case that, you know, many people can agree on, like Sandy Hook, this extreme tragedy. And what happened there would be like some of the stuff that, you know, when Alex was deplatformed, you know, it just it makes it easier for a lot of people to say, yeah, sure, get rid of this guy, but they're not going to come for medical misinformation, or they won't come for this or that, and which of course they did. And so I watch it as kind of is it a canary in a coal mine? And I think one argument I heard was, does this open up judgment in the future for people who say something that the government doesn't like, and then also happens to be emotionally inflictive on somebody? Does this open up a whole new legal category for saying something people don't like and then getting sued out the wazoo for it? And I mean, I don't know the answer to that question. Is that taking to an extreme side that we don't have to worry about? Because like I said, I just look at Alex as somebody who's easy to write off and say, whatever, he's just like in this category that we don't have to worry about it coming for the rest of us. But it did after the social media platforms got rid of him. And I just kind of wonder about that question.
I don't think it's a question of whether that's something we need to be concerned about. I think it's obvious we need to be concerned about. I don't think that's even a question, because what happens is people say it's like a slippery slope. It's not like, is there a slippery slope? I think anyone who really thinks, if you think about it, it's not like, is there a slippery slope? There is always a slope. The question is whether it's going this way or whether it's going that way. We don't know how to make things even. We don't know how. There is always a slope, especially when you have situations where politics are involved. Do I think that Alex Jones did something wrong here? Yes, I do. At the same time, do I think that there was political persecution that was happening here, where maybe certain agreements as to what he has to turn over in discovery were a big deal more extensive and allowed by the court because of the fact that he was Alex Jones? Yes, I think that's definitely possible. I mean, it's definitely, and if you looked at the judge's attitude throughout this trial, it seems as if I'd be surprised if that didn't happen. It was very clear that the judge had a disdain and like a disgust for Alex Jones. And there's certain exchanges between them where she looks as if she's reviled by his presence in her courtroom. At the same time, does that mean that, look, and that could happen with any individual, it doesn't have to be Alex Jones. So, you know, that might not be an anti-conservative bias, but I think that's, you sort of start questioning if this is what she's displaying on TV in front of people, that, you know, when she knows that this is all going to be aired to the public. To me, I was like, okay, he's kind of screwed here. He's really kind of screwed here. And I was talking earlier how you can have two things true at the same time. I was talking about Eric Schmidt and whether he has a personal ambition, and at the same time he could be right. I think over here, like, even though I think Alex Jones is wrong, I still think the fact that this has progressed the way it has is reflective of a slope that is not just like this, but it's pretty scary. It's not like it takes a long time for this slope to work downhill toward everyone else. It seems like it's coming faster and faster, where instead of it just being someone who's, you know, a big player, like as if someone like you or me are not very far down the road from that either. And it's a terrifying thing to say that if someone says something, if I say something and someone takes that as license for me endorsing, you know, improper behavior, that they take it to that extreme, that now I should be held liable. I think that the objective, let's think of the intent, the reason to hold me liable for that is to chill free speech, is to basically make me afraid that, oh my God, if I say something that's deemed controversial, the next thing I know, I could be bankrupt. And the same way they tried to bankrupt Alex Jones, and they'll spend millions of dollars in litigation trying to defend myself. I will tell you this: if you're an Alex Jones fan, Alex Jones, I'm telling you, had a party last night when this $4 million judgment was entered against him. I think he was very, very happy with it. I think $4 million, even though it's a ton of money,
for us.
For you and me, for someone whose company is even bringing in 100,000 a day, yeah, I would say it's a lot. He's fine. He's gonna be fine, and he's very happy about that. And I also don't think that was, by the way, not the punitive damages element. There's a second. The jury is still supposed to decide whether or not they're going to award punitive damages, and if they award punitive damages, how much they are. I think they're capped somewhere in the $8 to $9 million range, and as far as those punitive damages, I don't expect he's going to get hit with anything on punitive damages.
Okay, so Christina was also bringing up during Alex Jones' trial, they were trying to blame him for things his guests had said, like Wolfgang Halbig. Asked Joe his thoughts on that type of liability for guest comments, because that's also kind of terrifying for somebody like me, because I bring on guests. I cover censorship, so I mean, I bring on very controversial people because I want to give folks the opportunity to hear directly from them. What do you think about that?
That sounds all the more terrifying. That sounds all the more terrifying. I have almost like a running gag because I do a live stream every night, and like sometimes when I have a guest that says something that I know can get me in trouble, I'll start like just yelling at them, saying like, "What are you doing? Oh my God! Like I disavow. I don't know this person," and I'll because I want to make it clear that no one should tack that one on to me. Yeah.
Do you think I should start that tactic? Don't listen to me. I don't have anything to do with Joe and his NYPD hat. All right. He can't even spell Lawgic right. I don't trust him. He's nuts.
Yeah. I mean, it does make it all the worse. I don't think it's that much better because any words you say, any statement you say can be taken however people want to take it. It's like, it's so easy to turn into a political witch hunt. It's a joke. So like, I don't really, I mean, obviously it's just that much further removed from the host. At the same time, Alex Jones wasn't doing himself any favors when you're skipping days in court. That doesn't look good. He's not there when the plaintiffs are taking the stand. That's not looking good. He's going on InfoWars talking about the case and saying things that basically can be deemed insulting about the litigants during the course of the trial, like saying like, yeah, I think the dad is slow. You don't do that. They literally play that in court. Like, that's just you have to realize you're talking to a jury who's human there, and they're basically going to be like, they did an effective job of making him look like he's a jerk. So they might believe in free speech. In Texas, you would think it shouldn't be too hard to find a jury that's going to believe in free speech. Even if it's in Austin, which is, there's going to be certainly more liberal, but it's going to be more liberal than it will in like, the in Arlington or whatever, some less Democrat concentrated area. But look, let's face it, a liberal in Texas is not the same thing as a liberal from California, New York, or Chicago. So even the liberal there is not going to be nearly as far left. My point is, if you're enabling the plaintiff to show you displaying anything other, any kind of lack of remorse, or that you're still profiting off of this case while the case is ongoing, and they get information about how much money you're making, I think that he's thrilled that he got hit with $4 million. I think the plaintiffs were crying. I think they were crying when they saw the guy they only got $2 million apiece. I think they were crying. You have to realize the legal costs come off the top, then a third is going to the attorneys. So, I think he probably offered them each $1 million up front before all of this. I'm sure, trust me, that having $1 million in settlement apiece, which I'm not sure that that's accurate, so I don't want to be quoted on that, but if that is true, right now, if you're the plaintiffs, assuming they get no punitive damages, which I don't think they're going to get because you need to get unanimity on punitive damages, and they only got 10 jurors here. So if you need unanimity and it's unlikely that all of a sudden two people who said that they're not entitled to any compensatory damages are going to say that they're going to get punitive damages. That seems almost impossible to believe. So that being the case, I think that they're probably not going to get any punitive damages, and I think the plaintiffs are very, very disappointed and that and Infowars, they were popping the champagne last night. To you and me, it sounds like, oh my God, you just lost $4 million. To them, I think they're like, oh my God, thank God. We thought we were going to hit with like $100 million judgment. We didn't know what they were going to hit us with.
Okay, let's wrap it. We'll do just really quick Steve Bannon. I will play a quick clip of this. We tried to do this when you were covering this case in person. That's you in the background with the blue and white striped shirt.
I still hate that guy in the yellow shirt. I still hate that guy.
Is that the guy blowing the whistle?
The one in the yellow shirt, yeah.
Okay, this guy right here.
Yeah. He's wearing a mask. He's got a whistle. He has a whistle under the mask.
Okay, let's hear.
The Moscow show trial of the 1930s. Why is he not here in person? Does he really have COVID? Has anybody checked at all, or is he just saying he has COVID? Has Dr. Fauci come forward? Okay,
before Steve Bannon gets me taken off YouTube. Yeah, so let's just relive that moment for a second. So he's blowing a whistle trying to that must hurt. You're standing right next to him. That must have kind of hurt your ears.
I'm telling you right now, I wanted to punch him in the face. I really wanted to punch him in the face. And I was actually, as I was filming this, because I have the filming of the recording of this from the other side of it, I was thinking to myself, like, yeah, if I punch him in the face, I'm gonna go to jail. I'm totally gonna go to jail. If I engage with him in any sort of physical way, I'm gonna go to jail. So I was just like, all right, just hold your bag in one hand and your phone in the other, and just wait and just. But people started trying to like walk into him to like sort of, and he was circling around to make sure that he was staying there. And here's why it's really disgusting. It's because he's trying to silence Bannon because he thinks that, his content isn't fit for human ears and or should not be heard by other Americans. And he's relying on the fact that we are all sufficiently civil that we're not going to punch him in the face. Yeah. So it's like, he's abusing our civility and using it as like, well, no one's going to hit me, because this is not like someone who's relying on his own physical prowess. He literally looked like someone in one punch in the face, he would be in a hospital for months. So he's relying on our civility to get away with being a complete a-hole. And that's what makes it so completely offensive.
Okay, I want to talk more about the Bannon trial for like another 5 or 10 minutes before I let you go, but I don't want to do it on YouTube, mostly because I just, even at the end of this video clip, I can't let Steve say what he says. So thank you everybody who's watching on YouTube. We did an hour, so anyway, we'll we'll see everybody on ROKFIN and Rumble Live. If you want to see it, go over to Locals. Good Lawgic. I'm not endorsing him. Okay, so if the judge comes after me, I'm not endorsing it by saying go there so you can see all this misinformation.
You're a wise person. You're a very wise person for disavowing,
maybe I should just
dissociating. No one should ever want to be associated with me. Trust me.
It's making me think of like all these very professional people that I bring on, like doctors, who are going to be so offended if I go, but don't listen to anything. I mean, I'm just letting you guys know they're probably total wackadoodles. Like, I try to be clear. It's funny that you brought that up because I do try to be clear to people, like to question and be skeptical and like, here, I'm just bringing this person on. I'm not an expert. This is for you to ask the questions. So I don't know. Well, maybe I'll be in that courtroom next. But I can assure you I'm not making $800,000 a day. That's for sure. Okay. Glad to see everybody on YouTube. We'll see you over on ROKFIN and Rumble. Also, the full thing will be up on ODYSEE and Locals later. Have a great weekend.